I'm Gordon Thompson. The Arizona Supreme Court has held that the owner of a cell phone does not lose their privacy protection for the contents of the cell phone if they leave it unlocked in another person's apartment. The Supreme Court also held in the same case that an overnight guest in another person's apartment does not lose their expectation of privacy in property that they have left in that apartment, even if they have temporarily left the apartment or even if the apartment's owner dies. On September 12, 2016, in State v. Robin Peoples, the Arizona Supreme Court upheld a trial court's order suppressing the use at trial of the contents of the defendant's cell phone, as well as statements the defendant had made after the cell phone was illegally searched. The court did so because the search was made in violation of the defendant's Fourth Amendment rights. Although not necessary for the decision, the court also held that the cell phone had been illegally searched in violation of the defendant's Fourth Amendment expectation of privacy as an overnight guest in the other person's apartment, and therefore suppression could have been granted for that violation as well. The facts of the case are the defendant lived next door to his girlfriend, D.C., in an apartment complex. The defendant frequently spent time at D.C.'s studio apartment. About 3 months into the relationship, the defendant spent the night at D.C.'s apartment and used his cell phone to film the couple having sex. D.C.'s daughter, who also lived at the complex, found D.C. unresponsive in bed the next morning while the defendant was still in the bathroom. The daughter called 911 and the defendant ran from the apartment to direct the paramedics, leaving his cell phone behind. While the paramedics were tending to D.C., whom they were ultimately pronouncing as dead, the defendant sought solace in a friend's upstairs apartment. No one asked the defendant to leave D.C.'s apartment. A police officer came to D.C.'s apartment after D.C. was pronounced dead and looked for information that might identify D.C.'s doctor, hoping the doctor could shed light on D.C.'s recent health and then sign the death certificate. The officer found a smart cell phone in the bathroom. Assuming the phone belonged to D.C., the officer turned it on and opened it with a finger swipe to search the contents. It was not passcode protected. A pause video image of D.C. on her back in bed, mostly naked, appeared on the screen. The officer pressed play and watched part of the video of the defendant having sex with a seemingly unresponsive D.C. Before he watched the video, the officer had been told that the defendant spent the night in the apartment. The defendant returned to D.C.'s apartment a short time after leaving and asked a second police officer at the door to receive his cell phone from the bathroom. According to the defendant, that officer entered the apartment and later returned, handcuffed the defendant, and took him to the defendant's apartment. The first officer testified he was never told about the defendant's request for his cell phone. According to the first officer, after viewing the video, he detained the defendant in his apartment, read him his Miranda rights, and questioned him about the video. The defendant confirmed that he had sex with D.C. during the early morning hours and filmed it with his phone. The defendant also told the officer that D.C. was probably dead when they were having sex, although he thought she was breathing and had heard her snoring earlier. The defendant later watched the video with other officers and answered their questions. The state charged the defendant with necrophilia and 2 counts of sexual assault. The defendant made motions to suppress the contents of the camera or the phone, the video, and his statements. The court granted the motion to suppress. The state appealed to the Court of Appeals, which reversed the trial court's order of suppression. The defendant then appealed to the Arizona Supreme Court, which in turn reversed the Court of Appeals' decision, and in doing so reinstated the trial court's order of suppression. The Supreme Court said the primary issue was whether the defendant had a legitimate expectation of privacy in the contents of his cell phone or in D.C.'s apartment as an overnight guest at the time of the police search. If he did, the state conceded that there was no exception to the warrant requirement of the Fourth Amendment which applied to permit the search, and therefore the search would have been in violation of the Fourth Amendment. The Arizona Supreme Court said that in Riley v. California, a 2014 United States Supreme Court case, that court said that since cell phones are essentially their owners' digital alter egos and contain a digital record of nearly every aspect of people's lives from the mundane to the intimate, the privacy of cell phones is protected by the Fourth Amendment. Since a cell phone's contents are protected, the police must generally get a warrant before searching a cell phone. The Arizona Court of Appeals for this case had said that the Riley case was inapplicable because by not having the cell phone within his immediate control when the officer found the cell phone and searched it, the defendant had lost his privacy expectation in the phone's contents. The Arizona Supreme Court, however, said that the issue is the contents of the phone and not the phone's location, and therefore a person does not lose their expectation of privacy in the phone's contents if the phone is not in the person's possession or even if the person chooses not to lock the phone. Since the defendant did not lose his expectation of privacy in the phone by leaving it unlocked in D.C.'s apartment, the court said the warrantless search was a violation of the Fourth Amendment. The Arizona Supreme Court went on to say that the good faith exception, under which even if evidence was obtained in violation of the Fourth Amendment, would be allowed into evidence to be used at trial if the police had obtained the evidence with a good faith basis to believe that the law and the facts permitted them to obtain the evidence, and that did not apply in this case. The court declined to apply the good faith exception because it said the officer did not have a good faith basis to believe the phone belonged to D.C. and not the defendant. When the officer first viewed the video on the phone, the officer could see that D.C. appeared to be unconscious, and therefore it was unlikely that she was using the cell phone to make the video. The officer also knew the defendant had been in the apartment, and therefore it could have been on his phone. However, the officer chose not to ask the defendant if the phone was his. Therefore, the Supreme Court said the officer was not acting in good faith when he thought the phone was D.C.'s. Had the officer had a good faith basis to believe that the phone was D.C.'s, the good faith exception would have applied, and the order granting suppression would have been reversed. The Supreme Court could have decided the issue solely on the expectation of privacy and the cell phone's contents. However, the defendant had also sought suppression on the grounds that the cell phone was found in an apartment where, as an overnight guest, he had an expectation of privacy in his property found in the apartment, a right which is also protected by the Fourth Amendment. The state argued that the defendant had lost the expectation of privacy as an overnight guest in the apartment when he left, and if not when he left, when D.C., who had given him permission in the first place to be in the apartment, had died. The Supreme Court agreed with the defendant's argument that neither his temporary absence from the apartment nor D.C.'s death terminated his expectation of privacy as an overnight guest, and that expectation for his property that was found in D.C.'s apartment. The court also declined to apply the good faith exception to this issue because the officer knew the defendant had spent time in the apartment and did not ask him if he had gotten all of his property from the apartment prior to searching the phone. The case may be found at a link which is on this video.